another Probate Polymath podcast. I'm Keith Davidson.
I'm Stewart Albertson.
And we are with Vincier.
And
we have kind of an interesting topic to talk about today, or at least interesting to us and probably interesting to anybody who has a trust, whether they know it or not.
It is an interesting topic, and it's a topic that the courts in California have wrestled with for quite some time. And the issue is, how do you properly amend a trust, and how do you properly revoke a trust? And that leads to a myriad of issues, such as, do you do it per the trust terms? Do you do it by the probate code, which we call the statutory term or the statutory basis for amending or revoking a trust? Or do you do both? And the courts have been a little bit all over the place. I'll just key this up real quickly, Keith, and get your thoughts. There's a case that came out February 8 of 2024 by the California Supreme Court, Haggerty versus Thornton. And it seems to be the answer, or at least it's the Supreme Court's attempt to answer the issue versus amendment and revocation. And by the way, they use the word modification at times, right? That means an amendment. And it overrules four primary cases that the appellate courts had wrestled with. Those four cases are King versus Lynch, Pena versus Day, Balistreri, and Diaz versus Zuniga. And all of those cases had one holding, and the Supreme Court went its own way and made its own determination. So why don't you take us and fill us in from there?
Yeah, I mean, it's a huge change in trust law based on what we had before, I think. And you take a case like King versus Lynch, for example, and that said that if a trust had an amendment provision, that's the provision you had to use. So you couldn't use the code, you couldn't use anything else, you had to use that provision. It's very different from revocations. So even before under King v. Lynch, there was a case by the name of Masry, and Masry said, you can revoke by the trust terms, or you can revoke based on the code, and you could use either or. It didn't matter which one you used, unless the trust said that its way of revocation was the only way of doing it. And most trusts don't say that. 99.9% of trusts are never going to say that. But with amendments, it was different, and because amendments are under different code sections. And so under King v. Lynch, it said, well, if you have an amendment, just by virtue of the fact that you have amendment provision,
you
makes
need to follow it.
The exclusive method. Yeah, you cannot do anything else except for follow it.
Right.
And that all changed now with Haggerty. And so now what we're going to see with Haggerty is that they decided that amendments are the same as revocations, basically. And so any way that you have to revoke a trust, you could use that same method now to amend a trust. And it's a really interesting and wide-ranging holding, and it's going to have a lot of ramifications that I don't think people could even imagine yet, because it's going to have a huge effect on how this all works.
So let's take a step back and think about what we're talking about here. So for the layperson out there, husband and wife create a trust, and in that trust, that they put all their assets in there, and then when both of them pass away, the trust terms dictate how those assets are passed down. Well, people set up a trust and then they live for many years afterward in many cases. And so there's provisions in a trust that allow you to make changes if you change your mind on something, or some new facts come in, maybe it's, new beneficiaries are born or something along those lines. And so to change a trust, you got to keep that power because it's a revocable trust. And so they include two sets of different terms. One is that they have the right to amend the trust. That means they can modify some paragraph or something in the trust, and then new paragraph that they create takes precedence over the old paragraph, but the rest of the trust stays in place. There's also the nuclear option, and the nuclear option is, hey, I don't like this trust anymore. I want to revoke it. I want to get rid of it. And so we're going to toss it out. And so let me ask you this. Under Haggerty versus Thornton, it seems like the lowest common denominator is, find me the least path of resistance for revoking this trust, and if it's out there, you can do it. Is that an accurate assessment?
Yeah, that's exactly right. So if, like some trusts will say you have to have a signature and a notarization, and you have to deliver it to the trustee, and that's what the trust terms say for revocation, and maybe they have something else for amendment. Well, the code says something different. The code says you can use that. You can go ahead and do the signature notarization, but you could also just amend under the code, which is just a signature, no notarization. You don't have to have it notarized. Just sign a piece of paper, give it to the trustee. Well, now Haggerty says you can amend that way too. So whatever way you have to revoke, you now have the same methods to amend, even if your trust has an amendment clause. So the amendment clause in your trust might say you have to have it signed, you have to have it notarized, you have to have it blessed by the Pope. I mean, whatever it is that says.
Right.
And Haggerty says, well, you can do that, or you can just follow the way of revocation under the code. And I have the code section here.
This is 15400 or 15401.
We're looking at 15401. And this is the first part of 15401 says you can revoke any way the trust tells you to.
Pull that up real quickly, Keith. I think that's important.
Okay. So let's look at the first one. This is going to be kind of interesting here. So tell us about this one here. This is the easy one.
So again, I think this is where Haggerty comes along and it says, we're not going to treat amending and revoking the trust under two separate doctrines. We're just essentially going to say a revocation is an amendment is a revocation. And if you can find the path of least resistance, like I said, where a revocation is easier to do than an amendment, even under the trust terms, under the statutory scheme, all you have to do here under 15401 1 is by compliance with any method of revocation provided in the trust instrument. So keep in mind, if the trust document says anything about amending the trust and requires extra things to do for amendment purposes, as long as you have a revocation provision that says you can do it by a revocation provision, then that's what you can do to amend your trust.
That's an important point too. So what you just said, whatever the trust says on revocation, if that's the easier way to go, you can now use that for amendment. It's so important to keep that in mind because it really makes it, it's exactly what you said. You take the path of least resistance and boom, that's what you do to either revoke or amend.
And why this matters, Keith, and I know you're going to get into this, is that if there's an amendment, that could be done in secrecy, right?
Yeah.
And a revocation, that can't be done in secrecy because if you revoke a trust, where do the assets go back to?
They go back to the settlors, the people who contributed them.
And so I'd wake up one day and go, oh, my house is back with me. My bank accounts are back with me. Something has happened.
Yeah.
Versus one of the spouses making an amendment, even though it might be under the revocation terms that are less restrictive than the amendment terms.
Yeah, and that's really important because imagine if you have spouses and one of them decides, well, I'm not going to leave all my assets to my husband. I'm going to leave my assets to my kids. But the husband...
Or my girlfriend.
Yeah, exactly. But the husband's leaving it all to the wife. None the wiser that something has changed. And so it's really kind of an unfortunate result when it comes to, certain joint trusts. And I don't think that the Supreme Court... they didn't have a joint trust in front of them, so they didn't decide about joint trust. But this is going to have an implication on it nonetheless.
So that's important. That Haggerty versus Thornton, that was just decided by the California Supreme Court. Obviously, there's general rules that we can extrapolate out of that opinion, but it's important to note that that was a single settlor trust where she had obligated herself to do a notary if she was going to do an amendment properly, right?
Yeah, that's right.
And so then under King versus Lynch, that means she would have had to follow that amendment procedure. And if she didn't get the notary done, even though she fully intended to change her trust and amend it and give her assets to someone else, if she did not comply with that amendment provision and include the notarization, then it was not a valid amendment. And so now Haggerty comes along and says, no, unless the provisions in the trust say this is the exclusive method of amending, or this is the exclusive method of revoking, which, like you said, we just don't see that in trusts, then you can, if you can't amend it under the trust terms, let's look at the probate code, because the probate code is going to give you a mile wide open gate to walk through to amend that trust.
Yeah, and that's a good point. So let's do look at it. So going back to 15401, and right here we have the first one we talked about. You can amend by anything in the trust, but check this out. Let's go down to 15401A2. So right here, you can amend by a writing other than a will signed by the settlor or any other person holding the power of revocation and delivered to the trustee during the lifetime of the settlor. So in other words, you have a writing, you sign it, and you hand it over and you take it over to the trustee and you say, hey, here's my amendment, and you've now complied with the probate code, even if your trust says you have to do something else like notarization, you can see right here in the code, there's nothing here that says anything about notarization in that yellow highlight. You just have to have it signed and delivered. End of story.
That's the big distinction with Haggerty. And then I think the other big distinction with Haggerty is, which we've already talked about, is it no longer distinguishes between an amendment and a revocation. If you have the power to revoke, and it's less strict, like I said, than the power to amend, that's good enough to do an amendment. And I think that's going to be a significant change in how people do estate planning going forward.
Oh yeah, it's going to be huge. And if you look at the second part of this, if the trust instrument explicitly makes the method of revocation provided in the trust instrument exclusive. So that's what you were talking about before. So if the trust says this is the only way you can possibly revoke this trust, then fine, that's the only way. You can't use the code. Most trusts don't say that. You're never going to see that in any trust that you ever see. Let's take a look at the modification provision. So here we have 15402. So this is the amendment section of the code. And this is the part that was decided differently under King versus Lynch and now Haggerty. So it says, unless the trust instrument provides otherwise, if a trust is revocable by the settlor may modify the trust by the procedures for revocation. So that means you can do anything that you can do to revoke, you can use to amend. But unless the trust instrument provides otherwise, that's really the crux of the issue, because the King court, an appellate court decision, said, well, that means that if you have an amendment provision, the trust provides otherwise, so you can't use the code. Haggerty said, no. Just because you have an amendment provision, that does not make it exclusive, and you don't have to follow it if there's another way, and so you can use another way.
Yeah, and Haggerty, if you pull that back up, Haggerty actually addressed that issue in the opinion. If you read the opinion, and maybe you'll link the opinion in the comments below, there is a provision that it actually defines what does unless the trust instrument provides otherwise mean. And I guess if you're just reading that for its plain words, that could mean all kinds of things. But Haggerty says, no, what that means is to meet and qualify, unless the trust instrument provides otherwise, it has to be the exclusive method for amending or revoking that trust. And that's the only way it could be provides otherwise. And I think that's an important distinction between King versus Lynch, the old way of looking at this, and Haggerty versus Thornton going forward.
So if we were to go out and talk to a dozen people who have trusts, who aren't lawyers, and we ask them, how do you amend your trust? What would they say in response?
Well, they wouldn't know how to amend their trust, but and I think that's what Haggerty's trying to address, and that is, let's say that you're not a lawyer and you truly want to, you want to disinherit one of your sons, and you want your other son to receive everything. And so if you truly wanted to do that, you go see a lawyer, and the lawyer just messes up. The lawyer doesn't read the amendment provisions in the trust, doesn't read the revocation provisions in the trust, but neither one is listed as being the exclusive method. But it requires you to send a letter through the United States Postal Service with a stamp that's turned sideways, with a smiley face next to the address, and that would effectuate an amendment or revocation. Yeah. Obviously, that's quite onerous to do, and you would never know that as a layperson. You're relying on your lawyer to figure that out, but you truly intend to disinherit one of your kids, and you really want to do that. And so I think what the court's saying here is we really want to meet the intent of what the settlor wants here, the creator of the trust, and who they want their assets to go to, but we don't want to hold it against them if their lawyer doesn't read carefully the trust provision. So what Haggerty says is, that's fine. You tried to disinherit your son, but you didn't put the stamp sideways. You didn't put the smiley face by the address. The court in Haggerty says that's fine because you didn't make it the exclusive method. So let's go look at what the probate code at 15401 has to say about this. And 15401 says you can do it by a revocation method that is in the trust, but you can also do it by the statute. And the statute says much less onerous, and that is a writing delivered to the trustee, and that can effectuate an amendment or a revocation.
Yeah, so it's almost user-friendly, isn't it? So even if your lawyer messes up, that's okay. You can still use the code, and maybe the code is much simpler, the code is pretty simple. I mean, a writing signed by the settlor, delivered to the trustee. I mean, that's about as simple as it's going to get. And so that way, in large part, it's kind of hard to mess it up. Although you still see people messing it up nonetheless.
Well, let me ask you this. So there are certainly some community property aspects to the analysis here. And so obviously the general rule for community property, you and your spouse, are you allowed to give away their part of the community property? Are you allowed to give away your own part of the community property? And so we have to get into the family code, which, we love the family code, right? We want to get into the family code and the probate code and read them together. But what are some of the issues you need to be thinking about from a community property standpoint? Because Haggerty did deal with a single settlor trust. What about husband and wife? What if they have different terms and different rules for amendment and revocation? And then, of course, it leads you to presumably the family code 761.
Yeah, and that's where things get a little messy. And the family code, community property laws do, I guess for lack of a better word, you can say that they trump trust laws, but not in every way. But there are important community property aspects to property going into a trust. And so one of the rules that is set down by Family Code 761 is that when community property is put into a trust, it remains community property. So that makes sense. That's what everybody would expect, I think. And then Family Code Section 761 goes so far as to say, when it comes to revocation, you can actually revoke with one signature as to community property, unless the trust says otherwise. So if the trust requires two signatures, then so be it. And it's kind of interesting because if you read the legislative comments to Section 761, it actually explains that the reason why it could be revoked by one spouse is because it preserves each spouse's right to give their assets to whomever they like. So if you think about it, if you put your assets in a trust and you want to amend it to give some money to your brother, and your spouse hates your brother and says, no, absolutely not, I'm not going to agree to that. Well, under community property laws, you still have the right to give your half the community to whomever you like. And if it wasn't in a trust, you could easily do that. You could do a will, whatever you want to do. And so what they did under 761 is they figured, well, if we allow for unilateral revocation, if only one spouse can terminate the trust, that's fine because they'll terminate it. The assets will go back into the name of the spouses, and then the spouse who wants to leave money to their brother can simply do a will and leave something to the brother. So it allows each spouse the right to kind of pull the plug on the trust plan if they don't like it, and they don't necessarily have to get the other spouse to sign off on that. And so it does make some sense when you look at it from that perspective. But the trust could also say, this trust can only be revoked with both spouses' signatures, and if that's the case, then that's what you'd have to follow.
And and then Haggerty wouldn't come and save the day there in the sense that you'd have to follow the trust terms under that analysis.
Yeah. So under that analysis, if the trust gives a different way, because in my mind, it comes down to the power of revocation versus the method. And so the power of revocation belongs to one of the spouses as the community, unless the trust says you have to have two. Now the power of revocation requires two people to exercise that power, versus the method of doing it is, it's a writing that's signed and delivered to the trustee. That's the way you go about revoking. But when you think about the power of revocation, under 761, you can have the power in one person, or you can have the power in two people, and you can specify that in your trust. But if you don't specify it in your trust, then the default rule is one signature will revoke.
So let me ask you your personal opinion. Did the Supreme Court get it right in Haggerty?
That's a tricky question, because I think that there's so many unintended consequences that come from a ruling like this. And I think that there's a lot of people who relied on the earlier King versus Lynch ruling, where if you had an amendment provision, that's what you had to use. And so lawyers, I think, knew that and relied on it. I think also that if you ask the average person out there who's creating a trust, who's not a lawyer, they would think that if they have an amendment or revocation provision in their trust, that that's what you'd have to use. It would probably never dawn on anybody that, you don't have to do that. You could also do what the code says. And I don't think planners are in tune with the exclusivity language of the code the way litigators are. So we're used to litigating these issues. We're very in tune with that language, but most planners don't litigate, and so they're not that sensitive to it. And so you very rarely see an exclusive method, but there's going to be a lot of unintended consequences from this. And I almost wonder if the ruling under Lynch might have been a little bit easier. The thing that I found interesting in Haggerty is that the appellate court in Haggerty, so before it got to the Supreme Court, the appellate court had a little bit of a different ruling that I kind of liked better, which is if there was an amendment provision, you had to use it, but you could use any other methods in the code to amend, but not necessarily the revocation provision in the trust. In other words, if amendment and revocation were treated differently in the trust, then that's the way it had to be, even if you defaulted to the code. I like that rule a little bit better. Saying that you can amend by any means that you want to, I think it's going to end up adding a lot of confusion and a lot more litigation down the road. That's just my personal opinion on it. What do you think?
So again, if I'm ever before the California Supreme Court, I want you to know that I don't think they make any mistakes, and I love all their opinions.
Of course not. Neither do I.
I wonder, with the no contest clause legislation, they would have an era of legislation that would be in place, and you would rely on that era of legislation. So in other words, the law changed like 4 times over 10 years, let's say. But whenever a trust was created within that particular era, the law would apply from that era. So you had 4 changes over 10 years. If you happen to be in the first era, then that's the law that would apply, and so forth, all the way to the most recent change, and that would happen after a certain date. I didn't explain that very well, but what I'm trying to get at is if Haggerty would have only been applied to all cases after February 8 of 2024, I think it would have allowed estate planners to get into place to address some of these trusts where there's more stringent provisions for amendment, and that makes sense, versus a single signature for revocation, for example. And at least it lets it gives people time to digest the ruling and figure out how that goes forward from a planning standpoint, and certainly from a litigation standpoint going forward. But to let Haggerty be the law of the land and it goes all the way back in time, it's tough because there's drafting that was done based upon King versus Lynch, which was a 2012 case, and Pena was a 2019 case. Balistreri was a 2022 case, and Diaz was 2023. So if you go all the way back to King says, hey, if there's an amendment provision, that's what you got to use. And I agree with you. The Haggerty court, the appellate court in Haggerty, I think they found a nice common ground that I was thinking that's what the California Supreme Court was going to do. But they didn't, and so they've given us this. It applies to all trusts of the land now, and so there'll be some cleaning up probably in a minority of cases. 10 years from now, this won't be an issue because hopefully people will have digested Haggerty and include that into their estate planning and drafting.
Yeah, that's right. And I think you're right on the money with that. But you're right, with no contest clauses, it seems like the law changes every 10 years. So yeah, King's been around for almost 12 years now, and now we have a whole different ballgame. But it does go to the point of if you want to control revocation and amendment in your trust, then just make it exclusive. And I don't really understand why more people don't do that. I think it's not a bad thing to do. It's a perfectly good thing to do. And I think the other reason why I would do it is it would keep your trust from being subject to unintended consequences. Because when you're doing all these analyses under Haggerty and you're looking at revocation law and amendment law, it actually gets quite complicated very quickly. And the way to decomplicate it in your trust is just to say, this is the exclusive method. Don't look anywhere else. This is what I want you to do. And so now if I was doing planning, I would make exclusivity, standard in my trust document across the board, I think, because it would stop unintended consequences. So,
do you think this is the last word on Haggerty or on amendments versus revocations? I mean, it seems to be the Supreme Court doesn't take that many probate cases up, so it's at least going to be here for a while.
Yeah, if we're looking for a court fix by an appellate court or obviously the Supreme Court, yeah, you're probably going to wait another 10 to 20 years. I guess in my mind, I'm wondering, will you see a change in the legislation? So will there be a suggestion by Texcom and all the people that suggest legislation to now come in and say, hey, let's clean this up a little bit. It's a little sloppy. But on the other hand, some people like the way things are, and maybe it benefits them. And it probably depends on from what perspective you're looking at. So maybe estate planning attorneys like all the different myriad ways of revoking and amending. Whereas as litigators, we don't like that because there's too many, open holes. I don't know. So we might see some legislation on this issue. I think there should be. I think it'd be really nice to have the code revised to make all of this crystal clear as to what you can do on revocation. Even if the result is the same as Haggerty, I still think it would be nice to codify it and make it all, much easier to access and understand.
As litigators, I'm sure there'll be days that we love Haggerty, and then there'll be another case that'll come along and we won't be so happy. So as long as we understand what the rules are and how they're going to be applied, that's helpful. So I think the Supreme Court did a good job in doing that. But it's hard to do. I mean, you're taking one case with one set of facts and you're trying to make general rules that are applicable across the board. And it's just hard to do that. And if you look at we were talking earlier, and if you look at the Internal Revenue Code, the Internal Revenue Code has a general rule.
Yeah.
And they'll state, the general rule is X. And then they have like 40 exceptions to the general rule. And at what point does the general rule cease to exist? Because you have all these exceptions. And of course, that's rich for litigators, right?
Yeah.
And you brought up the idea of, what about those statutes that require you to act reasonably? What does acting reasonably mean? And so I do give kudos to the California Supreme Court for taking on a very difficult matter, a difficult concept, and trying to give us guidance on how the justice system, the courts, are going to view amendments and revocation going forward under the probate code.
Yeah, and I think it's a very common sense decision. I think it made sense under those set of facts that they were presented with in Haggerty. I just think that it's like anything else. When you don't practice in the area regularly, you may be prone to not seeing the complexities. And so I just think that there's a lot more complexities here than could be appreciated with just one case with one set of facts. But that's often the case. And I'm sure you're right. There's times when we're going to love Haggerty and times when we're not going to love Haggerty. But, that's the nature of litigating cases. So,
yeah. Well, it was a fun one. I'm glad we could spend a few minutes to go over it.
Yeah, that was awesome.